Thank you very much. Welcome to today's program. As mentioned, this is General Liability, Umbrella, Excess Coverage, Commercial Auto, and Workers' Compensation, Episode 3 of Financial Poises Insurance for the Business Owner 101. You can read more about financial poise on slide 40. Our panelists for today are Catherine Smith-Dedrick of KSD Law, Lee Burke of Burke, Bogart, and Brownell, and Adam Zerwinski of Sidebar Insurance. My name is Jonathan Mayotte. I am your moderator for today. You can see our names on slide 6, and you can read our bios on slides 33 through 37. Neither Financial Poise nor we intend for this to be an infomercial, so you don't need to listen to me read those bios. If you want more information about us, just check out the bio slides. Speaking of slides, do not worry if you're only listening but not watching this webinar. You'll be just fine. Slides are not critical. They're here as an additional tool. Financial Poise webinars are supported in part by sponsors. The sponsors for this webinar are Sunburst Digital, maker of Type to Learn, the #1 typing app for children K through 12, Max Asset, excuse me. If you need to conduct an online auction, Max Asset is your turnkey solution. And Mood, the nation's premier online retail cannabis dispensary. More info is on slide 3. Now, the last thing before we begin, there is a disclaimer. You may see it in front of you. It's on slide 5. The short and sweet of it, you are not our clients. We are not your lawyer. We are not your insurance agents. What we do here today, it's for your general education, and it's not for you to act on without appropriate advice. So, without further ado, let's jump right in. I hear the water's fine. General liability and umbrella coverage. Lee, I'm going to start with you. Tell us, what is general liability coverage? What's umbrella coverage? Why would a business owner need that?
Okay, thank you. First of all, I wish the insurance world had called it negligence insurance rather than liability insurance, or general liability insurance. Think of using the word negligent rather than liability, because in the legal world, liability is based on negligence. So liability insurance or negligence insurance basically is there to protect an individual or a business in the event that they do something, again, probably something negligently, that causes either injury to somebody or property damage. So you can injure a person, you can cause property damage to their property or their assets. If you do that through some type of negligence, a screw up, a whoops, an accident, whatever the case may be, then liability insurance is designed to pay the claim on your behalf, or pay the damages or the injury that you caused, and more importantly, provide defense coverage to protect you in the event of a lawsuit or a claim. So you've got somebody there that is experienced in this area and can defend you. Liability insurance comes in, we'll call it 2 layers, call it a 2-layer cake. There's primary liability insurance that you typically would buy for a business on an automobile, which we'll talk about later, or in other forms. And then there's umbrella liability, which is simply a second layer or additional coverage over and above the primary liability for those businesses or individuals that need large amounts of coverage.
Is there a difference between umbrella coverage and, say, excess liability?
Yes. Now we're going to start getting a little wonky. We're going to get into some insurance terms. Umbrella liability, well, let's start with excess liability. Excess liability, again, is that second layer of liability coverage, and it sits on top of and pays when your primary insurance is exhausted or runs out. And it provides coverage which what we call following form. So it is exactly the same type of coverage as you had on your primary liability insurance. It should not be any less in terms of what it covers. It's not going to be any broader or cover any additional things. An umbrella policy does the same thing, but it is broader coverage. The umbrella policy will provide that second layer of insurance when your primary insurance is exhausted. It will also provide certain types of liability coverage and protection when you do not have primary liability insurance. So think of it as an umbrella in a storm. It's designed to hopefully keep you, keep you protected, and more than just the rain falling right down on top of your head, but falling around you as well.
I like that analogy. Uh, just a thought here. Is it important if you're a business owner to make sure that the insurance carrier is fully aware of all of your operations when it comes to your liability policies?
Yes, insurance is a promise. It's a promise to pay. It's basically a handshake agreement. It's a big, thick legal contract, but it started out years ago as a handshake agreement. And a basic fundamental part of that handshake agreement is that the parties are being open and honest and exchanging information in a full and forthright manner. So the insurance company needs to know not only what business you're in, but how you do business. It's very important to make sure that your agent, your broker, your insurance company understands and knows your business, what you do and how you do it. And you do that through an application. You do that by conveying information to those respective parties. Likewise, the insurance company has an obligation to fairly treat you in claim situations, and they will almost always do so as long as they knew they know or they knew what you were doing when you wrote the policy. If you fudge and don't tell them some important facts, that's where a claim problem might come up.
Nobody wants that uncovered claim because they left something off the policy. That's never a good thing.
No, and I'll throw it out to you all because you all see these situations. In my experience, about 80% of claim problems originate when a policy is written. Something went wrong right at the very start of the process. If you get it right early, and a lot of that is exchanging information, they're very, very seldom claim problems.
I would agree 100% with that.
I think I'll jump in and say I've maybe seen a little bit more problems arising um, from the application of the policy to the factual situation. And it's really important to have a good broker, a good agent, a good attorney who is steeped in this, who, if you run into a situation where the insurance company is saying, denying a claim or refusing to defend, because the other thing the GL policy does is provide payment for defense fees and costs. It's really important to reach out to folks who are in the industry to be able to look at the situation. And often there are ways around a denial or a refusal to do certain things with the insurance company.
Absolutely. Yeah, thank you. So switching gears slightly here, moving on to commercial auto. Adam, I'll turn it over to you real quick. Describe commercial auto, what's covered, and kind of how is it different from, say, your personal auto policy?
Yeah, thanks a lot, Jonathan. So commercial auto refers to vehicles, and that can be anything from a personal automobile to pickup trucks or dump trucks or even semi trucks that are owned by the business, right? So the key in insurance, and often people overlook this, is the ownership. The entity, in this case for business owners, the entity that owns the actual vehicle is the one that should be insuring it. So oftentimes what we run into are, particularly on personal conveyances, vehicles owned by a business but insured personally is a big pitfall for a lot of folks, in just making sure that it's insured correctly, because insurance stems from the ownership of the object. So just one thing I would just highlight right off the bat is, if the vehicle is owned by the business, you likely want to at least explore a commercial auto policy or a policy that will name the entity as an additional insured, because that ownership is where the insurability stems from. Now, when we deal with commercial auto policies, they operate differently from personal auto policies in several ways. And one is symbols. So there are different ways in which an insurance policy, an auto policy, may categorize the type of policies that they use, or type of vehicles they cover. Oftentimes, this is subject to a schedule where all VIN numbers as well as drivers need to be listed, so that the insurer knows who's driving what vehicles, and then that way we will identify the coverages that attach to each specific item. This oftentimes is very burdensome and very task and specific and very task oriented, and there's a lot of attention to detail. So keep that in mind when working with your insurance professionals to keep those up to date and accurate. And then I would also they deal differently when it comes to coverage, because the wide breadth of the type of vehicles covered under a commercial auto policy, you see much more restrictive insurance terms. So whereas you maybe feel comfortable handing the keys to your personal car to your neighbor to run to Lowe's, doing that with a commercial vehicle can have very different consequences should they get in accidents under different policies. So it's really important. The commercial policies are often more expensive, more restrictive, and more specific than you see with more generic or general personal auto policies. So keep that in mind as you're evaluating the insurance risks, and also keep in mind that big price difference, because it may not be all it's cracked up for that. The accountant may advise, hey, you want to make sure that you want to write this off for depreciation through the business. Well, that depreciation write-off may not cover the difference in auto insurance premiums you have by bringing that into or being owned by the commercial entity.
A quick follow-up for you, Adam.
Yeah.
If a business doesn't own a vehicle, should they still get commercial auto insurance?
Yeah, this is a great question. It kind of ties into Lee's earlier comment. There's a type of coverage called hired and non-owned auto insurance, which generally is found under the general liability policy for most office risks, but can, in some cases and some carriers, be purchased separately. This policy will cover any vehicles that are not owned by the vehicle, but used in the course of business for the business. So if your assistant were to drive to Walgreens to get plates for the company luncheon and get in a car accident, because they're in their course and scope of their work for the business, it could subject your business to liability, any injuries or car accident that happens as a result. So while that hired and non-owned auto insurance policy may not fix your assistant's car, it likely would protect the business from a liability standpoint, should there be one. And I think it's also a good point to tack in with this. Another point on Lee's earlier explanation, those umbrella policies, one of the other things they do is they can actually offer coverage over the auto and the general liability through a single policy. So one of the other differences between an excess policy and an umbrella policy is an umbrella may consider your workers' compensation employer liability component. It may consider your auto liability component. It may consider your general liability and extend coverage beyond as a secondary level under those policies. Excess policies generally are specified to one specific line of coverage. Particularly, we see it in malpractice or errors and omissions policies and or EPLI policies, more specific, and that excess will only extend for that one area of risk. So to tack in with some of what Lee said, that umbrella policy can also help you out from either that hired and non-owned auto perspective, the auto perspective, or the workers' comp.
Excellent. Thank you very much, Adam. And while we have you here, we want to switch gears and kind of jump into the workers' comp area just a little bit. If you could kind of tell us who's covered under a workers' comp policy, what are some of the big things that business owners should be aware of, maybe some misconceptions that might be out there about workers' comp and who needs it?
Yeah, great. Thanks. Absolutely. It kind of ties into my last comment about workers' comp. So workers' compensation, generally speaking, is a statutory and regulatory kind of area of recovery whereby employees can seek coverage for their injuries that they suffer as a result of their work. And generally speaking, these are governed by commissions set up in each state. A word of warning for certain businesses that are either in certain states or in multi-state scenarios. If you are in specific states that are called monopolistic states, generally speaking, this is Ohio, Washington, I believe Wyoming. There's been a few others. Idaho was this way for a little bit.
North Dakota.
North Dakota, I'm sorry. So great. So those states mandate you purchase the workers' compensation through the state's program. Generally speaking, though, workers' compensation affords your employees recovery for their medical bills, their time off of work, and some form of settlement at the end of the claim. Workers' compensation policies are usually mandated by either local law or state law. And if in the event of not having coverage, you may expose yourself to additional damages which aren't otherwise recoverable if you had the insurance. Please also note that the workers' compensation policy is there to help in events that a third party sues for the injury of one of your employees. So like a spouse or a child, if they were to allege that you are somehow, as the employer, responsible for their injuries because of the injury of your employee, the workers' compensation policy is the one that responds. And this is under the provision of employer liability, not the general liability policy. So a lot of times, we deal with businesses that are like, oh, we're low risk, we don't have an injury. And not only are they flouting the law, but they're also risking the chance that not only their employees, but their employees' dependents would make claims against the business. So this is an essential part of almost every business's risk management plans.
And just a follow up on that, a lot of times there will be businesses who rely a lot on independent contractors or subcontractors. What should business owners do in those instances?
So it's a really important, independent contractors are a very dangerous place because based on my understanding of what I've seen, there's only really 3 entities that can determine an employee. And that's the Workers' Comp Commission in your state, the IRS, or the Department of Labor. And they all do that in arrears. They look backwards. Independent contractor is, and the difference between an independent contractor and an employee is oftentimes in the eye of the beholder. So even though you have written independent contractor agreements, certain states I know have specific ones that they allow. Some states will exclusively leave it up to their courts to determine whether or not it was an employee. So having a workers' compensation policy, even if it doesn't include or you don't think they're included, having one in case is an important piece. The other thing to do is that in the event you are using independent contractors, it is super important to collect their workers' compensation policy so that you know they have their own and won't be looking for yours. So these are really good tactics or strategies to make sure that the people who are working for you have their own policy, because oftentimes if someone gets hurt, they're going to look for anywhere to recover. And if you were the master and they were the independent contractor, they may come knocking at your door saying, no, I was an employee for purposes of when I got injured.
Yeah, I think if we all had a nickel for every single time somebody didn't collect the certificates and then got hit with an audit, we'd have enough to be able to cover the cost of the audit premium, most likely.
Yeah, that's just to
Jonathan,
jump onto that, Jonathan, and I think you bring up a good point, but to clarify what you mean by that, oftentimes your insurer, if you buy a workers' compensation policy, will say, give me those independent contractors' certificates before we ignore the revenue you paid to them. And if you don't have that, they will add that on and it'll be a significant bump in your premium. So just to kind of clarify what Jonathan meant, that is a scenario where it's a kind of a lurking risk. If you don't collect those certificates, they'll put the payment that you made to that employee, even though it's independent contractor, on your policy to protect them in the event of a claim.
Thank you very much for clarifying that.
Jonathan, can I add something there?
Absolutely.
In a lot of states, small businesses with maybe 2 or 3 employees are not required to carry workers' compensation. In addition, most states will allow owners or officers of a corporation to opt out of workers' compensation. And very often we hear employers say, well, my people have their health insurance, or we provide health insurance, or my family's got health insurance, I don't need workers' comp. It is very, very important nowadays to look at the exclusions in wherever you're getting your health insurance, whether it's a group policy, whether it's an individual policy, whether it's Obamacare. You will normally find that the health insurance policy is going to have either a full exclusion or a limitation on any coverage that it will pay for a job-related injury or sickness. The wording can vary and will vary from policy to policy, but it is not generally the intent of the health insurance company to pay any claims arising out of a work-related injury or illness. So when you don't provide workers' comp, or you don't cover yourself or your family for workers' comp, most of the time you are leaving a gap in coverage, and it can be a huge gap in coverage, particularly if you do any business travel, if you're in the car for business, or just active in a business situation where there's some kind of risk of injury.
Absolutely. No, couldn't agree more. Kind of want to switch topics here to something that just kind of want to touch on this a little bit because it's definitely a hot topic. Cyber insurance, cyber liability. Catherine, come to you on this. It's relatively new coverage in the grand scheme of things compared to general liability or workers' comp. Why is it so important that, as far as having the coverage and, areas that may pick up some gaps in coverage that aren't covered under these other policies that we've already discussed?
Well, cyber insurance is really important. I've handled a number of cyber claims, been called by clients who are in the middle of a cyber issue, and it's very costly. It can be incredibly costly. You need experts in the arena who can come in and figure out what's going on. You need backup for all your data. Hopefully, if you can still get access to your data, you might need to pay a ransom, which is often what is going on in these situations. It could destroy your hard drives and your equipment. So there's all sorts of things that happen, from a simple thing like an employee opens an email that is a phishing email, and now they're in your system controlling it. So, not only are you losing all the items I just talked about, access to data, maybe paying a ransom, but you're losing loss of your employee time. You're also potentially losing business because you can no longer conduct your business until this is resolved. So it's just a domino effect of what can occur. And cyber insurance was created, I've been seeing it about 10, 15 years ago. And it's not yet general liability and excess insurance are typically form insurance. They're ISO forms, meaning that the forms are pretty regular. The language of those forms are pretty regular. Cyber insurance is a different animal. It's got many different forms, different language, different coverages, different exclusions. So it's really critical to match what you're worried about in your company, to imagine what would happen if, what would we potentially lose? What would potentially be the loss of income? What employees would have to be involved, to consider your particular risks of your company and the coverage that you need for those risks. So you want to match your company risks in this arena. And this is really across the board, but it's particularly important for cyber because there's so many different forms out there with the form you want to buy. And cyber insurance covers both first and third party losses. What do I mean by that? Well, a first party loss are those things I mentioned, like if your business loses income, if you have data corruption, server damage, ransom, loss of your employee time. So cyber cover will, if the policy terms are met, provide reimbursement to your company for all of that. So first party loss means your company gets the payment, the insured gets the payment. But cyber insurance also provides third party coverage. That means when something happens, we've all seen the headlines where a particular company is invaded by some event, cyber event, and now credit card information is on the black web, and information, maybe personal medical information. Well, when that happens, there's a whole series of things that occur. There are state penalties that can be enacted. There are also the obvious class action lawsuits that might be filed against the company. There's reputational damage. So all of those things start. And a cyber policy will also provide third-party coverage, meaning it'll provide lawyers to defend your company in most of these situations. Again, depending on the policy language. Couple things to really look at that are important in cyber policy is many of them have particular a group of lawyers and a group of experts that you can call right away 24/7 if something happens. And these are folks who the insurance company has retained to get on the matter for you right away. And that's very important, very critical to have, so you're not searching for maybe an expert who you're not sure they know what they're doing. The insurers have vetted these folks and brought them on to provide that type of assistance. So it's really critical. I think the last point that I'll make is the SEC, the Securities and Exchange Commission, changed its rule for public companies. Now, if you're not a public company, a little bit different, but last year they changed their rules for public companies requiring reporting on material cybersecurity incidents. And so insurance companies have become much more stringent on what they require their insureds or their clients to implement for protection and before they'll insure them. So it's kind of a nice way of making sure that as a company, you've got a lot of protection in place, because typically the insurance company will demand that in any event. Things like, software firewalls, antivirus, system recovery software. There's a whole slew of things that might be required by the insurer. And it just kind of helps your risk management as a company to get all those ducks in a row. So it's really important insurance, particularly at this point.
I'm glad you hit on the cybersecurity infrastructure part. That was going to be my follow-up question. So thank you. And kind of jumping around here, Catherine, I kind of want to go back to intellectual property, or we didn't really hit on that, but kind of wanted to talk about that. How's it covered under general liability, and maybe we can expound upon that a little.
Yeah, intellectual property, or IP, so we know what we're talking about, are legally protected rights that are granted to entities or individuals for their inventions or creations. And these rights give the owners, whether they're a company or individual, exclusive control over their intellectual assets, and also allows them to financially benefit from their work. And these are things like patents, trademarks, copyright, trade secrets, designs, etc., those kind of things. And only certain claims are covered by general liability policy. And it really depends on how the claim is asserted by the complaining person or entity. But coverage B in the policies, and I don't want to get too technical, but it does provide coverage for personal and advertising injury. And the claims, some of these claims, like have to fit within the triggers or certain requirements of the policies. For example, they have to have occurred during the year. They have to meet the definition provided in the policy. There's a whole slew of things that has to happen before the coverage will attach. So in my opinion, for a company, I think it's really important that they consider, if they're heavy into some of the patent, trademark, copyright, and whether they need separate IP insurance or whether they think that the insurance provided by the general liability policy will cover them.
Very good. Thank you. Yeah, that's, I think, one that might get overlooked sometimes within intellectual property. Lee, I want to come back to you real quick with, I think, a very common question that you and Adam and I probably get, which is what limits are sufficient for general liability, umbrella, or auto policies? And I think I had somebody answer that one time and say, well, how much do you plan on getting sued for?
Yeah, thanks for the how high is up question.
Yeah.
Appreciate that. If you don't mind, I'd rather go ahead and just solve the Middle East peace question. It would be a little bit shorter. Yeah. I want to see Catherine's head nod up and down, which I think it will here. If you tell us the circumstances of a claim, what happened, why it happened, when it happened, where it happened, who got injured, how much they got injured, the extent of the injury, the extent of the damage, we probably could make an educated guess on how much liability insurance you need. But when you ask the question, in the absence of all of that, it is truly a how high is up question. So what I'm going to say is that there should be a thoughtful process that you go through to determine the amount of liability protection you have. It would be nice if we could buy unlimited liability protection, but that would entail an unlimited budget. And individuals and businesses don't have an unlimited budget, so that's not happening. As the amount of coverage goes up, the premium goes up. So clients, would rather pay less. They'd rather have less coverage. So there should be a thoughtful process that you walk through with your, again, your agent, your broker, your risk manager, and perhaps your legal advisor to determine it. Things like, first of all, what are your contracts? And when we all have contracts in our business with suppliers, with franchisors, with landlords, you name it, all of those contracts, or almost all of them, are going to have insurance requirements. They're going to have liability insurance requirements. They're going to stipulate how much insurance you, as the other half of the contract, are supposed to provide. Well, that's a contractual requirement. You may very well have regulatory requirements from a governmental entity, or a tax district or something of that nature. You are going to have business reasons to carry certain amount of coverage. If you're a mass tort attorney, and you're not carrying large limits of professional liability coverage, that may really impact your ability to sign up mass tort clients, because if you make a mistake in that liability situation, you could cost somebody tens of millions or hundreds of millions of dollars. Those clients may want to know that their potential claim is protected. So there's lots of outside reasons that you need to think about and evaluate to influence the amount of coverage. The size of your business, the profitability of your business, the type of nature of your business. I mean, if you're a catering firm, catering huge weddings, bar mitzvahs, bat mitzvahs, to high-end clients, you're serving hundreds of people food, you got to stop and think, what if the mayonnaise goes bad? I mean, how many people can I affect at one time? The nature and type of risk, again, going back to the nature and type of the contractual requirements. What's your risk tolerance? Are you a gambler by nature as a business owner or board member? Are you willing to roll the dice every day, put your company at risk, put your profits at risk, put your reputation at risk? That's an issue. A small business starting out, freedom. There's an old song that says something like, freedom is nothing is nothing more than having nothing left to lose. Well, if you don't have much, you don't have to worry about a lot of liability insurance. If you're a multi-billion-dollar corporation, you got a lot to lose. So, there are so many factors that go into it that you really have to sit down with a professional and just use common sense and walk through the process. And then, of course, you've got to evaluate the cost. You got to evaluate, can I get this much coverage? Insurance companies don't always want to sell you as much as you want to buy. So that's another issue. So it's definitely a how high is up question. I hope that answer helps a little.
No, I think that was very well said. It's a question that I think we all get, and it's nearly, I mean, there's so many layers to it. It's not just a simple, oh yes, you should get this much.
Yeah.
9 times out of 10, if we're really looking at it, I think. So kind of along those.
Can
sure.
I add? I think what Lee said is really important, and what we all kind of been talking about is the risk management piece of the business, right? Sitting down and considering what business you're in, what geographic area you do business in, considering if you sell widgets, how often do those widgets cause damage to a person or property, if at all? And when that happens, what are the type of verdicts or settlements that come in? I mean, these are things that the underwriters in the insurance arena, the underwriters are the folks who take your information and then decide on the amount of premium, whether they're going to write you as a company or as a risk. And they have to get that in. They just don't pull it out of thin air. They consider all those factors that go into then how much they want to charge in premium. And those are the same kind of factors that as a business, you can sit down and as Lee said, work through with a professional your best estimate on the risk and how much you want to pay and your risk aversion or not. All those things go into it. And then that's also why the excess or umbrella is important, because those are usually less premium, but they give you a little added layer of protection. And that's why those two things work nicely together.
Jonathan, I want to add one more thing on that subject, and Catherine
Sure.
touch base on it. you know, we mentioned before that liability policies, whether it be automobile, general liability, professional liability, one of the most important things they provide is defense costs. And more often than not, the liability insurance has got a stipulated limit. Let's say it's $1 million. But in terms of the defense costs are normally unlimited. The insurance company has the obligation to defend you and pay for that defense open-ended. Now, that obligation normally ceases if and when the insurance company elects to pay the policy limit. So you have $1 million coverage, you have an accident, it's going to be a serious injury, they're going to pay the policy limit. The insurance company generally can write their check, tender their $1 million to the court, and their obligation to defend you stops at that point. So they can cut off their defense expense. The best answer I have ever heard in terms of how high is up, in terms of or what's the right amount of coverage, is to have enough coverage so that in the event of any reasonable claim against you or your business happens, the insurance company is never going to tender their policy limits and walk away and leaving you high and dry as the insured to pay for your own defense costs. Because there is the best feeling in the world if you ever get sued, and getting sued is a terrible feeling. The best feeling in the world is turning to the insurance company and saying, you know, tag, you're it. You're paying the defense costs. Call me up when you're done. You don't want to be the person paying the defense costs.
Absolutely.
Jonathan, I want to just hop in and put a little appendix to Lee's comments, and just so that they are aware, not all policies operate that way. So he's absolutely right, and a lot of general liability policies, but there are policies, particularly cyber liability and particularly legal, like malpractice or errors and omissions limits, that have what's called CEIL. It says costs inside expense limits. And that means that what they spend on lawyers will reduce or investigations will reduce your overall limit. So it's important just to know that in certain areas, certain policies apply, and to make that part of the conversation when talking about limits, like Lee talked about. So you know that, hey, I want to buy extra coverage for this type of policy, so I account for those expenses that are going to draw down on our overall limit. Or this is a policy that doesn't have those costs concerns, and so maybe we can be a little more conservative with our overall limit because we're not worried about the expenses eroding our ultimate payout or the ultimate payout we'd have to make.
That's a huge coverage limit. Thanks, Adam.
Yes, thank you everyone for chiming in on this on that whole topic. Catherine, kind of along the same lines here, Lee kind of hit on it just slightly about contracts. You know, every business has a contract of some type. It might be with the landlord, vendors. You know, how do contractual obligations come into play with liability policies, the limits, and the endorsements?
Well, this is a great question, and Lee did hit on it a little bit. You know, you're going to have contracts across the board in your business, but many of them require things like indemnification, that for you to indemnify and defend the other entity if something happens, or to name the other entity as an additional insured. There's all sorts of things that are in the contracts you're going to get as you continue on in the business journey that you want to be aware of and ensure that you're hand in glove as best you can be with your insurer on any responsibilities that might arise based on these contracts. And I'll give you an example. For instance, if company A and B enter into a contract and company B is buying widgets from company A, company B may require company A to agree to indemnify and defend it if the widget causes damage or injury to a third party. These are things where company B is trying to, if company A manufactures, company B buys that widget and then sells it to a person, and that person gets damaged, hurt because of that product, company B wants company A to pay for that. And those are often requirements in contracts for production or something along those lines. You've got to ensure with your insurer that the the insurance policy will pay for that. That either that company, the retailer, company A, is listed as an insured, what's called an additional insured in the policy, or you've got what we call an omnibus endorsement, meaning an endorsement that says any contracts that you as a company enter into with another company that requires defense or indemnity for certain things will cover. So you don't have to list every single entity. But it's really critical to be careful with that, because even though an insurance company might say, okay, we did list company B as an additional insured, sometimes the language of those endorsements are so narrow or so time sensitive that it will not support your full obligation under the contract you entered into. So you want to be very careful. There's different kinds of endorsements to see if you can get an endorsement broad enough to be there for you if something happens under that contract, and to make sure that you're fulfilling your contractual obligations. And sometimes you may not be able to get that insurance that's broad or that, but then at least as a company, you've got certain coverage up to a certain point, and then you know that that risk is on your plate, and maybe you don't want to agree to that in the contract. I hope that helped a little bit.
No, very, very good, very helpful. Kind of along those lines, Lee, I wanted to kind of throw this back in your direction a little bit. Is it important when either before, during, or after, if you're entering into a contract with somebody, to get a copy of that contract over to your insurance agent along with your attorney?
Only if you like money and want to stay in business. You know, the business game that has been getting perfected for the last 30 or 40 years is to download as much liability, obligations, and bad things on the other guy in a contract that you can possibly do, whether it's a purchase agreement, whether it's a lease, whether it's anything else. And generally, the big companies in a negotiation or in a contract download an incredible amount of crud on the little guy. I mean, if you want to sell on Amazon, you don't negotiate with Amazon. Amazon tells you what you're going to do and how you're going to do it. And some of the provisions in contracts are incredibly onerous. They often cannot be met, and they can be very expensive. So you have to know what you're signing. You have to know what you're agreeing to. I mean, would anybody go get married to the girl or the guy behind door number 3 without knowing who's behind door number 3? I don't think so. But that's what you're doing if you're signing a contract and you haven't read it, you haven't talked to your legal counsel about it, and you haven't given it to your insurance or risk management professional to advise. Many contracts go for 10, 20, maybe even 30 years. You're signing agreements that are going to, 3 generations or 3 decades out, and agreeing to provide certain types of insurance or certain types of liability. You don't know if that's going to be available. You don't know what the cost is going to be. How do you take that kind of risk? It's insane. You've got to understand what you're doing. If I simply tell clients, and we all know, typically when do we find out about a contract? We find out a contract, months or sometimes years after it's been signed. When clients come to me with a contract they've signed and they've got a problem with it, I call it an Insurance Agents Relief Act. All you can do is tell them just to hold on to their ankles, because they don't, they're going to pay whatever it takes to comply. There's nothing you can do. Upfront is the time to do it. In the negotiations is the time to do it. And the other important thing that I would say from a practical standpoint, if company A wants to do business with company B, and company B wants to do business with company A, their attorneys, their green eye shade accountants, they're all going to play games trying to download as much crap onto each other and as much expense as they can. But at the end of the day, they're going to be reasonable, and they're going to negotiate a reasonable agreement because they want to buy and sell to each other. They can't afford to be too unreasonable in a contract. Otherwise, you go to their competition. So, the fact that the landlord wants to put provisions in the lease agreement that your insurance agent says, no, don't agree to these. Go back to the landlord and tell them to go find another tenant. You'd be surprised at how quickly that those changes can get negotiated.
Absolutely, especially when trying to find tenants these days is pretty difficult, but that's a whole nother topic for people that are not in this room.
Yeah.
Let's see. So kind of jumping back to general liability here, Adam, there's coverage for products and completed operations on the general liability policy. So what exactly does this cover, and why should a business owner be aware of it?
Yeah, it's a great question. When you look at a general liability policy, you're going to see some layers of different coverages that are being offered. And this is what Catherine mentioned on like Form B. A is usually the general liability. B is the multimedia. And down that list, you may see included things like premises rented to you or complete products or completed operations. This specific general liability provision generally refers to things sold in the stream of commerce, right? So if you're reselling, if you're selling an item or passing along another person the vendor items, product. That's for coverage in those events. However, what I don't want you to read into that coverage is it's not a replacement for malpractice or for errors and omissions coverages for the services you render to your clients. So those are generally need to be specific to whatever area or industry that you are in. It is a separate policy, but the products and completed operations is kind of a thrown on coverage for those things that are in the course. Now, if you're a retailer, that may be entirely different and it may not be found in the general liability. But if it's an ancillary product, let's say you do plumbing and you sell the putty that's on the back of your truck, that's what that coverage tends to come into play. And Catherine, I see you leaning forward because I feel like you have some color to add to this description.
I think that's pretty good. I think completed operations coverage is often important in, for instance, construction settings where they've completed the build and then something goes wrong later after the build. The cracks start to happen, half the building falls in. That kind of coverage is important to say, hey, it continued on. It continued after completion of the product, the build, whatever, and we want coverage for that. So, and then you've got to consider how long you want to keep that coverage in play too for general liability policy. So your description was perfect.
Yeah, and another follow-up on that, and Adam or Catherine, if you want to take this, are there exclusions sometimes for certain industries or certain types of work when it comes to products liability that people should be aware of?
Yeah, I'll jump in. I kind of hinted at those. I mean, if you're rendering a service, you're a doctor, dentist, lawyer, accountant, you're doing very educated or nuanced work. That's not what this policy is intended to provide. The services you render are generally being covered by your malpractice, errors and omissions policy. These are kind of ancillary kind of things that come along with it. So if you're, selling a ledger book, you're an accountant, you're like, hey, this is a good practice, keep your ledger book. And then it turns out the ledger book has some defect or something that leads to someone being injured. That's the type of products coverage that is provided by this one. It's not going to cover the returns that you did for either the corporation or the individual, right? That portion is the errors and omissions. It would be outside of the scope of a products and completed ops. Catherine, you want to add on?
Yeah, I mean, it doesn't cover things like recall costs. Typically, if a product has to be recalled, employee injuries or accidents involving customers like slip and fall. So it's a very specific type of coverage and is really particular to the manufacturing, the selling of a product. But then the insurance carriers do a pretty good job of narrowing that down. So you really, in the exclusion section. So you really do want to take a look at the exclusions, depending on what you're doing.
Yeah, this part of the conversation is more a warning more so than a like, hey, this is what it does for you. We don't want you to over rely on products and completed operations because it says, oh, completed operations, it's whatever I do. That's certainly not the case. You need to walk through and understand that those are additional policies. And think on just more broadly, think of your policies as like nets under a tight walk, right? You're the tightrope walker running a business. The net doesn't go the whole way. You're trying to set these out in important areas, and you may need multiple of them to make sure you get to the other side.
Excellent. There's a term that gets tossed around from time to time. It's called tail coverage. Lee, if you don't mind, kind of tell us what tail coverage is, how does it apply, and when would a business owner need tail coverage?
Okay, thank you. First thing is, it's important to understand that liability insurance is generally sold with one of two types of contracts. And by contracts, I simply mean the policy wording, the language. There is an occurrence liability policy, and there's what's called a claims-made policy. Not that one is necessarily better or worse than the other, but they're used primarily in different circumstances. If you can get an occurrence policy, you're generally better off getting that. But lots of times you will buy what's called claims made coverage, particularly with something like professional liability or products liability. You'll typically see that written nowadays on a claims made policy. And a claims made policy covers claims that happen during the policy period and claims that are brought, made known to you, and the claim is filed and initiated either within the policy period or within a designated period of time, a relatively short period of time thereafter. So there's a window of time where the event had to happen and you really had to be notified of the event. And as long as those two conditions apply, the policy responds just fine. Catherine, you want to look how you wanted to.
I was just going to say a lot of those claims made policies also have a requirement has to be reported within the policy period. So made against you, and then you've got to get on the horn and report it quick.
Thank you. Absolutely true. There are other conditions in the claims made policy. For lack of a better term for our lay people out there who would call them, it's another gotcha. There are gotchas in the policy that can affect your coverage. So you have to be very, very knowledgeable and careful if you have a claims made policy. The occurrence policies we'll simply call them a little more relaxed and a little more user friendly. But one of the big issues with the claims made policy, again, is that the claim happens, you're notified of it, and you notify the insurance company within this designated window of time. Well, that window of time is not always sufficient. It's not always sufficient. If you renew the claims made policy year after year, that window just keeps moving forward and it works great. But suppose you're a law firm and you got three partners in your law firm and you get an offer to get acquired by a larger law firm, and it's a great offer, and you do that. Well, the new firm says, hey, we're going to provide liability coverage going forward for everything you do, but anything that's out there that you don't know about that happened at your old firm, you have to be responsible for that. Okay, on the surface, that seems okay. But then you realize, wait a minute, once we don't renew our existing policy at our now defunct firm, we only have a short period of time to report a possible claim. What happens if 6 months or a year or 2 years from now, somebody says we missed a deadline, we missed a filing, we did something wrong in a case, and they sue us? Tail coverage extends that reporting period, the time you have to notify the insurance company of a claim so that there will be coverage applicable. There are lots of situations where this happens. It could be in somebody retiring. It could be in a merger or acquisition or a purchase. It could be with products liability. The product's going to be out being used in the workplace and in general use for the next 20 or 30 years. You want coverage going forward for that. So basically, if you have a claims made policy and you're not going to be renewing that policy or a similar policy with another company going forward, you may want and need to purchase tail coverage to continue the liability coverage for effectively for past events. Past events normally that you're not made aware of yet. It's an accident or problem that's happened that simply hasn't been called to your attention. That's the simplest information I can give you.
And often the statute, you know, the way the question would be, well, how long do I keep doing this? And often the answer would be, well, based on the claims that might come from your activity or your widget, how long is what's called the statute of limitations, meaning how long does someone have to sue you for that? And that's typically the boundary for when you should keep purchasing tail cover.
Yeah, or it may very well be, hey, we've got our business is still got a lot of accounts receivable out there. We have assets that we need to liquidate, et cetera. We're going to have significant assets and everything until we dissolve the corporation for a year or 2 or 3 or 4 years. That's another consideration. I mean, once the business doesn't have any assets and you dissolve it, there's a reasonable degree of protection there.
And I have a quick follow-up. We've got a few minutes left related to tail coverage. If, say, there's a merger and acquisition going on, you're selling your business, and the person who's buying it comes back and wants coverage on something that you didn't have coverage for, say, perhaps malpractice insurance or employment practices liability, is it still possible to get a tail?
The answer is generally yes. It might be expensive, but if you go to specialty underwriters, and we'll think of Lloyd's, the one that everybody has heard of Lloyd's. If you go to a place where there are real insurance professionals and they're used to taking risk. I mean, Lloyd's absolutely understands the risk-taking business. You can go and buy almost anything from Lloyd's at a price that they will sell it to you. Doesn't mean you're going to want to pay for it. But for those of us who are old enough to remember, many years ago, there was a huge fire in a Las Vegas hotel. If I remember, it was Bally's, but please don't hold me to that. And there were a number of people killed and a number of people injured. And after the fire, it was 6 or 9 months after the fire in the insurance trade news. It was incredible news, and everybody was just open mouth that, again, I'm going to say Bally's. I'm not sure it was Bally's, but Bally's had purchased $100 million worth of liability protection retroactive to before the fire. Lloyd sold them $100 million worth of liability coverage retroactively to before the fire. Now, why did they do it? They were a public corporation. They didn't want to carry that unknown liability, that contingent liability on their books. It would have limited their ability to get any type of financing in the financial markets, et cetera. They went to Lloyd's, and Lloyd's basically looked at it and said, you know what? For whatever the premium was, 10, 15, $20 million, we'll get that money today. We'll invest it. We'll make money. These claims could go on for 15 years. We'll have the premium. We'll make enough money to pay whatever claims come out of this. So that's a crazy example, but these type of things do happen.
Absolutely. Well, that kind of brings us up here to the top of the hour. So I think we will go ahead and wrap things up right now. A big thank you to Lee, Adam, and Catherine for just an excellent presentation and sharing your knowledge with all of us. And again, thank you to Financial Poise for hosting this. And hopefully you learned a lot about insurance from this. So thank you very much.
Good
Thanks,
job,
Jonathan.
Thank you.
Thank you.